Members, welcome to this meeting of the Subcommittee on Prison Amendment Rules 2025. I call to order the meeting. Let's invite the government representatives to join us first. While we wait for the government representatives, I'd like to tell members that this meeting is scheduled for 4 hours and there will be a break halfway through the meeting. Welcome, Secretary, Director, as well as representatives from the Department of Justice. Please be seated. Members, please refer to the background brief prepared by the Electoral Secretariat. Please also refer to SBCR 10/1/5691/89 issued by the Security Bureau on the 16th of July this year, LN 174 of 2025, paragraphs 53 to 55. On inviting public submission, I have the following suggestions. This item was discussed for about an hour on the 7th of July at the meeting of the security panel, and this amendment rules were gazetted on the 18th of July 2025 through the negative vetting approach, and it has taken effect already. If the public has any views, we will pass them to the Security Bureau through the Legislative Council Secretariat. Do members have any views on this arrangement? All right. We will first talk about the policy matters. Please refer to LC paper number CB bracket 2 1575/225 bracket 03 on the Electoral brief. I'll set aside 1 hour for discussing the policy matters. And depending on the progress, we can make adjustments to the schedule. Now I'll invite Secretary for Security, Mr. Chris Tang, to walk us through the amendment rules. Thank you, Chairman. I thank the subcommittee for holding this meeting even during the summer break of LegCo. This is to scrutinize the Prison Amendment Rules 2025. The rules, under the support of the Security Panel, on the 7th of July were introduced to the Executive Council on the 15th of July, and they were gazetted on the 18th of July. Before I walk members through the amendment rules, according to the decision of the National People's Congress, as well as the National Security Law, the SAR has the responsibility to continue to improve the legal system and enforcement mechanism for safeguarding national security steadily to prevent, suppress, and punish acts and activities endangering national security effectively. The prison rules have been around for about 70 years. There's a need for us to review whether the rules meet the needs of safeguarding national security. Upon our review, we've decided to amend the rules. We stick to the following 3 major principles. First, we want to continue to safeguard national security and reinforce the power of CSD officers. Second, we want to enhance the law enforcement effectiveness of the CSD. And thirdly, we want to make the rules more up-to-date. We are empowering through the amendment, allowing the CSD to impose restrictions, conditions, or prohibitions on relevant arrangements with regard to specific purposes to prevent anyone from endangering national security, posing threat to the security, good order, and discipline of the person, or impeding the rehabilitation of persons in custodies or PICs by abusing the regime. These specific purposes are known as key purposes. They include safeguarding national security, preventing or detecting any criminal offense, rehabilitating any PIC, safeguarding any individual's personal safety, and maintaining the security, good order, and discipline of the prison. With the above policy intent in mind, our amendment covers the following areas. First, we want to improve the visiting system for PICs. This is to clearly reflect the policy intent. Unless otherwise specified, any PICs must not receive visits from people not authorized by the Commissioner. Also, the purpose of the visits must be to help PICs rehabilitate or reintegrate into society. Through these visits, PICs will be able to maintain connection with their families and friends. And these visits should be able to offer mental or material support to PICs. The CSD has the right to reject any visits that do not meet the key or specific purposes. The CSD may also impose restrictions on certain visits to ensure that the visiting system is effective. The Commissioner for Correctional Services may authorize people to visit certain PICs, so we think that it is not necessary to retain Rule 51 to allow PICs to meet with their friends for the purpose of having bail. It is not necessary to retain the relevant provisions to allow a PIC to receive certain visits for repaying certain defaulted payment. In other words, the Commissioner may exercise his power to authorize a person to visit a PIC for the purpose of assisting a person committed to prison in default of the payment of a sum in providing for the payment. In relation to religious activities held by chaplains, the CSD may consider whether it is necessary to grant access to religious activities by chaplains to PICs. This is to enhance correctional institutions management and to prevent any national security risks. This amendment is not to impede PICs from enjoying the freedom to take part in religious services. They may still receive visits by chaplains that are authorized by the CSD. Therefore, the religious freedom will continue to be protected. Also, we made reference to the Safeguarding National Security Ordinance, and we made the relevant amendments so that based on certain needs, the CSD may apply to the magistrate for a warrant to restrict PICs from meeting with certain legal representatives. This is to protect national security. The PIC may meet with another legal representative of their own choosing, so they will still have the right to confidential legal advice and choice of lawyers. This is to also ensure that they will have a fair trial while they are in custody. Under specific circumstances, the CSD may apply to magistrate for a warrant to impose restrictions on visits between PICs and legal advisors. We are also imposing restrictions on visits by medical officers or practitioners to PICs. And under specific circumstances, the CSD may also apply for a warrant to impose relevant restrictions. Also, persons awaiting trial or PICs, they may consult other registered medical practitioners if they are met with the restrictions. Now, on the private clothing arrangement as well as private diet arrangement, to ensure that we impose clear standards on the clothing of PICs, we ask the CSD to come up with certain purposes on the private clothing arrangement. This is to ensure that PICs will wear clothes that are healthy. And we also want to ensure that PICs will wear clothes that meet the practical needs arising from different routine activities and their health needs. We also want to prevent risks from having PICs bringing in unauthorized articles. We will impose restrictions on the private meal arrangement. However, we will ensure that PIC's needs will be met, and we will also ensure the safety of prisons. Also, we are amending other provisions to clearly specify that CSD officers have to bear in mind national security risks as well as penal stability and security order. And these provisions have to do with receiving letters by PICs, dealing with publications from outside the prison, terminating visits between PICs and people outside the prison, as well as supplying means of occupation to PICs. Also, we want to reinforce the power of CSD. We want to prevent anyone from obstructing CSD officers in discharging their functions and duties. We want to ensure the safe custody of PICs and to ensure the security of prisons. Those who breach the law would commit an offense and liable to a level 1 fine that's $2,000 and 6 months of imprisonment. To tie in with the above mechanism, we will empower CSD officers to use reasonable force to perform their duties in cases where prisoners try to escape or engage in riotous conduct. CSD officers have the power to detain the arrested persons until the arrested persons can be handed over to the custody of police officers. Also, within reasonable means, CSD officers may use arms against PICs under the above circumstances. CSD officers will strictly abide by the relevant rules when they have to use arms against PICs. Like other law enforcement officers, CSD officers have to abide by the internal guidelines as well as the principle for the use of force continuum. There will be sufficient training to ensure that correctional officers shall use force to stop illicit acts and make arrests in accordance with the law only, within the reasonably necessary scope. To ensure that during the removal of PICs and while they are held in legal custody outside the prison, CSD officers may use mechanical restraints such as handcuffs and ankle cuffs approved by the chief executive. Also, we have made amendments to make the prison rules more up to date. Given that the reformed district councils have reverted their positioning to being district advisory and service bodies, which are not organs of political power under the Basic Law, we are taking away DC members from the definition of specified persons in the prison rules so that persons that fall within the scope of specified persons only include those whose duties necessitate the handling of PIC's complaints against CSD. After the amendment, the CSD will handle letters between PICs and DC members in accordance with the general provisions related to letters. That means the letters between PICs and DC members will no longer enjoy the special rights that is, for example, they won't be read by the CSD officers. We're also repealing obsolete provisions concerning corporal punishment and execution. We have drawn reference from the Basic Law as well as the relevant human rights provision. As we repeal these obsolete provisions, I want to stress that the PICs, they do not enjoy rights that are equal to the rights enjoyed by non-PICs. While they still enjoy certain rights, we must ensure that we have to bear in mind national security risks will not be compromised and that the security and order of prisons will not be compromised. We have drawn reference from laws in other jurisdictions, and their laws also abide by the same set of principles, and they also impose restrictions on PICs in certain areas. In other jurisdictions, as well as Western countries, there are relevant arrangements as well. So the SAR's amendment proposal are imposing restrictions on PICs based on the same principles, and we have to take into account proportionality as we implement the amendments. We have to make sure that we are protecting public order and security as well as PIC's right, and we have to strike a balance. The SAR government has to continue to improve the legal system and enforcement mechanisms, and we have to do this in a timely manner. The earlier the better. For safeguarding national security effectively, we have to reinforce the power of CSD, enhance the enforcement effectiveness of CSDs, and therefore the amendments are necessary. Now we welcome any views from members. Thank you. 6 members have asked to speak. I'll read out their names. They will speak in the following order: Reverend Peter Kuhn, Mr. Tommy Chen, Mr. Benson Look, Mr. Stephen Ho, Mrs. Regina Ip, Mr. Lai Tong Kwok, and Mr. Ben Chen. 7 members now. We have ample time, so I'll give 4 minutes to each member, including questions and answers. You can speak for multiple rounds. Reverend Peter Kuhn. I declare that I am a chaplain under the prison rules. Based on my past experience, I support the amendment rules, especially on the amendments that seek to repeal the obsolete provisions. I've talked to the relevant chaplains, and they all expressed their understanding and support to the amendments. However, I'd like to seek the administration's clarifications on the following. Just now, the Secretary mentioned that if a chaplain is restricted from visiting certain PICs, PICs will still be allowed to attend religious services. For chaplains that are restricted from visiting PICs, well, will they be allowed to visit the PICs after the trials concerned are finished? Secretary. The restrictions will be clear and solid. For example, we will specify during which period the chaplain is restricted from having access to certain PICs. As long as the visit will not violate the key purposes, then the chaplains will be allowed to visit the PICs. Also, the restrictions will not be imposed permanently. We have to look at why the restrictions are imposed. Mr. Tommy Jung. Thank you, Secretary. I'd like to follow up on the questions about chaplains as well. I've been supporting a group to work with young prisoners. After the implementation of the prison amendment rules, I talked to the chaplains as well, and the chaplains said they have looked at the amendment rules and that will not affect the years of work that the chaplain had been carrying out over the years. Now I'd like to turn to the point about private diet. I think there are currently 11 operators that provide private diet, involving about 400 persons awaiting trial, or PATs. And these service providers or meal providers will be impacted for sure under the amendment rules. That is the 11 service providers I'm talking about. Well, we have to understand that the relevant arrangement stemmed from the relevant laws in the UK, and that law was already abolished in 1988. And in South Korea, Macau, and Singapore, this arrangement does not exist. So the Liberal Party is of the view that we have to move with the times, we have to keep reforming to meet with the needs of managing modern correctional institutions. For CSD officers that work very closely to the private meal providers, I encourage that you ask them to patronize the service providers so to minimize the impact on these businesses. Thank you.
Secretary, Thank you for the sector being so understanding. We are of the view that private diet should no longer exist. As mentioned by Mr. Chang, UK has abolished the relevant arrangements. Many other countries don't have such a system. Currently, there are few problems arising from private diets. First, privileges, because some PATs only receive food from the correctional institutions, and some are entitled to private diets, and this is unfair. Second, we have to deploy manpower to look into the content of these private diets. Some people try to smuggle dangerous drug into the prisons via these private diets, so we have to deploy manpower to look into the beverages and food. Third, health issues. The food offered by the CSD has been assessed by nutritionists, but private diet sometimes is fatty, they contain high sugar, and that undermines the health of the PATs. And we think that, therefore, it's necessary for us to reform our regulations and rules. I'm sure that the business sector is flexible. They can offer meals to, for example, CSD officers who work near the prisons or in the prisons. Thank you. Mr. Chang, anything to add? No? Mr. Benson-Look. Thank you, Chairman. We amend the prison rules in order to continue to safeguard national security and its enforcement mechanisms. And we want to update our rules so that it's up to date. So I support it. I have a few questions. First, on private diets. As I said in the panel meeting, there is certain history behind the private diet system. The system was implemented because many years ago, no food was offered to persons awaiting trials in UK, and that's why there's such a system. And they already abolished the relevant arrangement in 1988. I know that the CSD has been deploying manpower to look into whether there is any contraband in the food and beverages. For PATs and PICs with special dietary needs, how will the CSD cater to their demand? Second, on private clothing. I know that there were cases of disorder in the correctional institutions arising from the procurement of private clothes. So I support the arrangement of CSD offering clothing to PATs that ensure their safety, comfort, health, and hygiene. When PATs arrive at the trials at the court, how are we going to make arrangements for their clothing? I hope that the administration will further clarify. Third, on receiving and sending letters. Under 47(4) of the prison rules, I know that there is some minor amendments, seeing that if a PIC requires a request to send letters to a specified persons outside the prison, the authority has to grant it. So I wonder what's the difference before and after the amendment to Rule 47A. Thank you. I will take the first two questions. For the third one, I will ask Mr. Leung from the DOJ to answer it. After abolishing the private diet system, we're going to offer 4 types of meal. Chinese meal for locals. Second, Western meals with breads and potatoes. Third, curry-based Indian meals. And fourth, vegetarian meals. for PICs and PATs with special dietary needs who require, say, soft meals or diet with religious restrictions, we are going to offer special food for PACs and PICs. On the point about private clothes, the requirements of attire on PICs, APAT attending trials has not been changed, so PATs can choose their own clothing when they attend trials. Regarding the third question, Mr. Leung, please. Thank you. There are some other ordinances that stipulate the requirements of clothing, that is where under Section 47 of the Criminal Procedure Ordinance. Regarding the amendment to Rule 47 bracket 47A, 47 bracket 4, it is said that if the PICs want to write letters to specified persons, say, for example, Legislative Council, Ombudsman, or Commissioner of the ICAC, the authority has to grant it. And if they usually write these letters in order to complain against the CSD and the CSD officers, and they should be allowed to send such letters on public money. Although this is a right of the PIC, it has to be granted by the authority. Because the authority will have to act in accordance with Rule 47A and Rule 47C. They have to conduct security screening of the letters to see if there is any prohibited items or articles in the letter before they can be sent to specified persons. Under our amendment, we ask the PICs to make a request to the authority to send such letters, and then the authority will conduct the security screening against the letters, and the letters will then be sent to the relevant specified persons. There is no significant difference in the arrangements before and after the amendment, because all along the CSD has been screening the letters for prohibited articles. We just want to expressly provide for the intent. Thank you. Mr. Stephen Ho. Thank you. I think that we should have amended the prison rules a long time ago, so the DAB supports it. I have a few questions on why we amend the rules. People may not fully understand about the private diet system. I hope that the administration will take this opportunity to inform the public about the reasons behind the abolishment. On food safety, when the private diet was sent from the outsiders to the PAT, the food may go wrong. And when the CSD inspect the private diet, they have to be careful, and I think that is better for the CSD to provide food to PATs. We also have to have regards to national security. Even after amending the prison rules, we may not be able to plug all the loopholes, but we should try our best. We should abolish the private diet, private clothing arrangements, so that they will not be able, the PATs will not be able to use the specified style of clothes to show off or take political stance. The administration said that they have come across 300 cases of disciplinary offense caused by private diet. How did the CSD make sure that there is no prohibited articles smuggled into the prison through private clothes. In 1988, UK abolished the private diet system. They perhaps did not abolish it because of national security concern, but disciplinary reasons. I hope that the administration will explain further. Thank you. I will take the first two questions, and then I will ask the Commissioner of Correctional Services to supplement. Thank you. I agree with what you said regarding the nutritional content of private diet. The CSD has to inspect the food, and that's why when the food reaches the PATs, it will be cold. And when we inspect the food, we try to be fast so that it's still warm when it reaches the PATs, and we will not try to destroy the food. However, if we have to move the food around, it will definitely affect its appeal. Second, there were cases where PATs wear private clothes with special signals or numbers to stage soft resistance. So it's necessary for us to abolish the private clothes system. I will ask the Commissioner of Correctional Services to further supplement. Thank you. Over the past 5 years, there were altogether 300 cases of disciplinary offense caused by private diet. Some of them, well, because we allow the drinking of alcohol among PATs, and once they get drunk, they sometimes scold or fight with other PATs. So PATs can enjoy alcoholic beverages via the private diet system. I think that we should have changed the arrangement a long time ago. Mrs. Regina Ip, thank you. There was a famous PICs who wrote to me all the time, who was a murderer. He was paralyzed from the lower body, and he said that he was not satisfied with the food offered by the CSD. His girlfriend visited him all the time. In the Thomas 1 V, Commissioner of Correctional Services, the definition of friend was set down, and it turned out that the scope of it is very wide. Now you want to narrow down the definition of friend. So other than specified persons, who can visit the PICs? So the Commissioner of Correctional Services will be the one to decide who can visit the PIC, am I correct? Mr. Yip Kai-fun's girlfriend visited him as a friend. What happens after the same-sex partnership bill has been passed? Can the same-sex partner of the PIC visit the relevant person in the prisons? How to define it? Should there be civil union between the two? Should they have been married in other countries? So that there will not be any judicial review launched or lodged by any PICs. Secretary, thank you. I will not comment on individual cases. In the CSD, we do have medical officers. If PICs need any special dietary needs or medication, I believe that our medical officers will grant such requests. But I don't believe that any person's health would be undermined if they don't have, say, traditional Chinese soup. We will make arrangements as associate. What about PICs with 3 highs? We do have medical officers in the CSD. PICs will be able to be prescribed with regular medication, and we do have custodial wards in public hospitals. So PICs will also be able to enjoy specialist treatment. Second, as to who can visit the PICs, well, that's exactly why we amend the rules. Currently, we allow relatives and friends to visit PICs, but the scope of relatives and friends is wide. People can argue whether one is a friend or not. Currently, we adopt two principles. First, if they visit the PICs to help them rehabilitate or reintegrate into the society. Second, whether the visit can allow the PIC to keep in close connection with the family and friends or provide moral support or material support. If the visit fulfills these purposes, then we will grant it. However, under certain circumstances, we can ban such a visit if they threaten the national security, if the PIC is benefited from criminal offense by the connection, or if the PIC's connection with the visitors will pervert or obstruct the course of justice. Unless, under these specified circumstances, the visit will be granted. So as long as the key purposes are not met, then the visitors will not be able to visit the PICs. That's correct. If the relatives of the PIC ask the PIC to do not cooperate with the CSD officers to launch soft resistance, then we will not grant such a visit, because that undermines the order, security, and discipline of the prison, and it may threaten national security. Thank you. Mr. Lai Zhongkwok. Thank you, Chairman. First of all, I think that it's necessary for us to amend the prison rules, because after the Black Cloud violence, we saw many disorderly conduct in the prisons. So I hope that we can plug all loopholes. If we see any new mode of incorporation, I hope that the Secretary will act in a speedy manner by amending the rules again. Under Rule 48 and 203 of the prison rules, the authority is empowered to impose restrictions on PATs and PICs, or even prohibit them from being visited by certain persons. I read the prison ordinance and prison rules. I hope that the administration will further clarify the definition of authority, or commissioner, or superintendent. Are you referring to the person holding the relevant office? Because under the government establishment, a superintendent may be acting the relevant position for a long time. It can be someone who has been substantiated as a superintendent. It seems that you are referring to a specific rank by the word superintendent in the prison rules and prison ordinance. I think that we have to clarify the power of the superintendent, because their duties is very important. So I hope that the Secretary will clarify. If we're referring to the office, but not a particular person, the superintendent may not be at the substantive rank.
Secretary, thank you. Chair, thank you. Mr. Lai, for your question. I'll have Mr. Leung answer the question. Let me first confirm this. For superintendent, whether it is a substantive rank or otherwise, they are covered. And we have also in the Rule 105, it is quite clear when the superintendent is not present, the commissioner may authorize another officer or delegate relevant powers to the chief officer of the Correctional Services Department, so acting arrangements will be covered. Sorry, I have some follow-up questions. I thank the DOJ for pointing out specifically what is said in Rule 105, but I can see in Chinese it seems that it specifically said that when the superintendent is absent, another officer may take up such duties. But I'm asking specifically, when it is an acting superintendent, do the relevant arrangements apply? And your explanation just now was very clear that it would apply, and I thank you for giving such explanation. Thank you. Dr. Chen Han-pen. Thank you. I welcome the amendments because when I visited prisons as a justice of the peace, I found out about the operations of correctional institutions, especially for private diet. It has caused some risks or some interruptions to operations. It has caused also some difficulties in enforcement. We have had 300 prisoners awaiting trial that had some issues with private diet. I think the public may not understand how the private diet system works. Can you elaborate on the operations of the system? I also note in the paper we have seen 300 prisoners awaiting trial having private diet, and we have had in the past 6 years 300 incidents, so every year we'll have 50 incidents. That ratio is quite high. And in the UK, they have abolished the relevant system in 1988. It is only now that we are considering to abolish such arrangements. It may be quite late, but I do support such amendments. I also want to, as I asked earlier, know more about the operations of this private diet system and what kind of incidents were you referring to specifically? Thank you, Secretary. About the risks and incidents involving private diet, I'll ask the Commissioner of Correctional Services to answer that question. Thank you. Regarding what Dr. Chen asked, the private diet system would work this way. Every morning, the contractors would convey the food in some trucks, for example, to the relevant correctional institutions, and we have designated time slots for us to deal with such operations in a more effective manner, and we have had 2 or 3 contractors provide such meals, and we would have some officers, regardless of the weather conditions, that would have to go outside to receive such meals. We would first clarify and verify whether those transporting such food are of the recognized contractors, and then for each private diet meal, we have to conduct some security inspections. We have to have, say, the beverages that are non-transparent, that we have to transfer them to vessels that are transparent, and then we have to have them inspected by machines. As for meals, we kind of have to rummage through the food. As the Secretary said, we have had contrabands hidden in meals before. So we have had officers having to wear gloves, and they need specified equipment to rummage through the food. We also have metal detectors to scan the meals to make sure there are no sharp objects. We also need to check whether there are drugs hidden in the meals. For example, the airports or the customs, they would have some testing with papers done to objects, and that is essentially what we'll do as well with such meals. And then the meals will be conveyed to the prisoners awaiting trial. But we have seen some incidents happen with such private diet because we have seen them trading. For example, an egg, they would hide such egg and then they would just keep such egg and then they would trade it with other prisoners to exert influence. So we have had some incidents where officers were unable to find everything that is a contraband. So the 300 incidents involve such where there were fights arising from prisoners awaiting trial, having disputes in relation to trading of such food, and we have had prisoners awaiting trial drinking, and when they got drunk, there were disputes. They assaulted other prisoners or even staff members. So we think there is a need to stamp this out. Thank you. Mr. Tan Fei, I think it is very clear that it is how the system works in relation to private diet and how there are different kinds of diet. I want to ask specifically about private clothes. Would it cover underwear? Would that cover, say, menstrual products? I think with most underwear, it should be generally the same, but then we have some people wearing corrective underwear, or if they have allergies, they may need to wear underwear of certain materials, say if they have dermatitis. Or as I said earlier, some may need to wear corrective underwear. Will these be excluded? If that is the case, the Correctional Services Department or the Security Bureau may have to elaborate on their justifications for such. Thank you. I'll let the Commissioner answer the relevant questions. Thank you. If there are medical needs in accordance with our existing mechanism, if there are medical reasons, if the medical officer thinks it is necessary for such to be worn, it is permitted. Thank you. Any follow-up questions? None? Mr. Dennis Leung speaking for the second round. Thank you, Chair. I would like to follow up on an issue mentioned earlier. In future, we will not need to conduct inspections because private diet will no longer be allowed. There won't be associated work that is done right now in future. So in future, for the Correctional Services Department, how much more efficient can your processes get? How have the abolishment of such arrangements help you with your work? I also understand some prisoners will have specific religious wear, and I understand that these people will be required to wear uniforms as well in future, even if their religious belief says they should wear certain clothing. Is that the case? And what are your justifications? Secretary, it is indeed the case that we will not need to conduct as many inspections, but there is additional work, such as the officers would have to distribute uniforms. So I don't think there's much room for a reduction of manpower. We still have a 10% manpower gap in the Correctional Services Department, so it would just be a slight alleviation of the burden on the Correctional Services Department. As for religious clothing, I'll ask the Commissioner of Correctional Services to answer the relevant question. Thank you. If one has medical needs or for religious reasons need to wear certain clothing, we will go with the advice of medical practitioners or some religious leaders. So there is no change with that after the change of rules. I would like to supplement information in the sense that with private diet, we have some additional costs. That's it from me. Thank you. All right, you are speaking for the third round. Mr. Stephen Ho, I'll assign a 3-minute time limit. I want to follow up on what is said in paragraph 12 regarding visiting rights. And in the prison rules, Rule 48.2, it says that the commissioner is empowered to have only suitable individuals visit the PICs or PATs to say for them to bail them out and whatnot, and they have to give reasons. So I want to ask, if you only go with Rule 48, it seems that there are no specific criteria. I understand that those who may endanger national security would not be regarded as suitable for making visits, but then I guess we should allow to a certain extent how they can have funds to bail them out. Secretary, we have had other people who are actually prohibited from, or they are not allowed to visit prisoners awaiting trial or PICs to make bail. So with our new criteria, which is, for example, facilitate the rehabilitation of PICs, prepare them for reintegration into society, enabling PICs to maintain connections with his or her family or with society, or providing moral or material support to the PIC. So they would fall under this category unless the key purposes are contravened. They will be allowed to visit PICs or PATs. So there's no need for a specific regulate or rule for those who need to make bail to meet with certain people. I think for them to make bail, it is very important. But then for those who are simply trying to collect debts, they may still be able to meet with such individuals, and they may show proof, say a debt collection proof. But then if it is forged, will there be any punishment? Well, I think it is about how we are trying to allow them to make bail only, not about debt collection. I think we should make clear. I probably expressed it in a way that can be misleading. Thank you. Mr. Lai Tong-kwok, I want to ask, when a superintendent applies to the court to prohibit PATs or PICs to connect with certain legal representatives, when they make the application, do they need to notify the PICs or PATs or the legal representatives? And the administration already gave a detailed response. In paragraph 14 of their response, they said there is no need. It would be an administrative arrangement. And I think it is an approach that works quite well because there will be more flexibility in enforcement. But I think the secretary should make clear also in paragraph 12 of your response, you said that when the Correctional Services Department is applying for a warrant from the magistrate, the PICs or PATs will receive support. So I want to ask, are there internal guidelines in future for you to notify the PICs or PATs while this application is being made? Because there is an issue with the PICs or PATs having to find another legal representative. So they kind of have the right to know. And I think you may not need to notify the original legal representative because there are different circumstances that may make this not ideal. But I think the defendant should know at least that the original legal representative is not someone they can contact in future. That is very clear. Secretary, please. I will ask Mr. Leung to answer the questions. Thank you, Mr. Lai, for your question. If a warrant is being applied or if a warrant has already been applied, the PIC or PAT should be notified because otherwise the Correctional Services Department cannot really enforce this. So if a PIC or PAT asks the legal representative to meet with them and the Correctional Services Department prohibits that, they need to give their reasons. So that is a right of the PIC or PAT. As for the legal representative, it would depend on the circumstances whether they are notified. There are various considerations. Say if the PIC wants to meet with their, or the PAT wants to meet with their legal representative, we can just notify the PIC or PAT that we have this rule and we have this warrant now. You cannot meet with the legal representative, but we have also a legal representative trying to make an appointment to meet with the PIC or the PAT. If the Correctional Services Department does not allow the legal representative to meet with the PIC or PAT, then the legal representative may be informed that there is a warrant. All right. We have had some members asking 2 rounds of questions now. Any other questions on policy matters? If not, we'll go into clause by clause examination. Any objections? None? All right. The legal advisor sent a letter to the administration on 31st of July in relation to some legal and drafting matters of the amended rules, LC paper CB brackets 21575/2025 brackets 02. On 4th of August, the administration has provided written response, LC paper number CB brackets 21582/2025 brackets 01. Both of these papers are set out in the agenda. Would the legal advisor please, when we are scrutinizing the amended rules, remind members of the specific provisions we should pay attention to and the legal and drafting issues? And members who would like to ask questions on a particular provision, please press the request to speak button at the juncture of the administration explaining the relevant provisions. We will first look at the Chinese text. If members have any questions or comments in relation to the English text, you may also raise them when we are scrutinizing the relevant provisions. I will now ask the Principal Assistant Secretary to explain Rule 1 of the amended rules. It would be B1542.
Prison Amendment Rules 2025. Rule 1. It's in Rule 2 to 35 of the amendment rules. Any questions? Please refer to the marked up copy. LC paper 1575/225 bracket 01. Let's carry on with the clause by clause scrutiny. Ms. Cheung, please. To facilitate the scrutiny work, for provisions that are of similar nature, we group them together. There are 6 major policy areas. Please refer to the reference table. We suggest that we look at the provisions in accordance with the 6 major areas. First, we will look at the first policy area, the visiting system. Please refer to page 12 to 14 of the marked up copy. Rule 9. It amends Rule 48. It is to clearly reflect the policy intent. Unless specified, no one shall receive visits from unauthorized persons, and this clearly states that the purpose of the visit is to help the persons in custody reintegrate into society, or to maintain connection with their family members, or to provide mental support and material support to prisoners. And Commissioner may, in accordance with Rule 48 bracket 6, that is, to safeguard national security, help rehabilitate prisoners, impose restrictions, conditions, or prohibitions on certain visits to ensure that the visiting system is effective. This amendment is about reinforcing penal management and to safeguard national security. Mr. Lai Tong Kwok. I want to ask about Clause 5. When certain restrictions are imposed, how will the authority inform the PIC or the PAT concerned? Administration. Normally, there should be a written notification, because the notification will specify clearly what kind of restrictions or conditions are imposed on prohibiting certain visits. As mentioned by the Secretary, normally the restrictions will be imposed for a certain period of time. Under serious circumstances, the restrictions will expire as notified by the authority, so these will all be written down. When the affected prisoner gets the written notification, will the prisoner still be able to obtain support? If the prisoner concerned lodge an administrative review against the restrictions, will there be ways to do that? secretary. The restriction is issued by the superintendent of the correctional institution concerned. If there are opposite views concerning the restrictions, then the prisoner concerned may lodge an appeal to the commissioner. Also, the prisoner may complain to the ombudsman concerning the procedures. The prisoner may also, through judicial review, express his view. Mr. Dennis Leung. Rule 48, 1 and 2. It is said here that the visit will have to be permitted by the commissioner. 4B says the visit must not be made otherwise than on the date and at the time specified by the superintendent. Is there a difference between the decision made by the higher-ranking official and the superintendent? Rule 48, bracket 6E, about maintaining the security, good order, and discipline of the prison. (203) bracket 6, 169 bracket 8, and 26 bracket 2 also have the same wording. Does that mean it includes the normal operation of the prison? If it does not include the normal operation, will you consider adding the phrase maintaining the normal operation, security, good order, and discipline of the prison as one of the purposes? Administration. On 48 bracket 1 bracket 2, we want to provide for a major principle, that is, anyone without permission may not enter a correctional institution. I think this is acceptable to everyone. Bracket 1 says, subject to these rules. That means if you want to enter the prison, you will have to abide by certain rules. What kind of rules? That cover bracket 48, bracket 3. Under the existing rule, Rule 48 about police officers, Rule 49 judicial officers. So under the pre-existing rules, certain officers may visit the prisoners. For those who do not fall under these officers, and if you still want to make a visit, you will have to get an authorization from the commissioner according to the amendment. So the commissioner will make the authorization. And the superintendent of the prison concerned will impose certain restrictions, and the restrictions imposed are different from the permission given by the commissioner. Bracket 6 here, about maintaining the security, good order, and discipline of the prison. Does that cover the normal operation of the prison? The answer is affirmative. Maintaining the normal operation of the prison. A CSD officer will only impose restrictions and conditions because the security, good order, and discipline of a prison is affected. Now please refer to page 34 and page 35 of the marked up copy about the rules of the visiting regime. It says, subject to these rules, a prisoner awaiting trial must not receive any visit from any person who has not been authorized under Sub-Rule 2. And the visit has to enable the prisoner to maintain connections with his or her family or with society, and to provide moral support or material support to the prisoner. As mentioned, the CSD may reject any visits that do not meet the criteria. The CSD may also impose restrictions or conditions to reject certain visits. And the major purposes considered are in line with those set out under 48(6), but rehabilitating prisoners is not included here. This is because PATs are not convicted yet, so that purpose is not applicable. About stepping up management of the correctional institution and safeguarding national security, these rules meet the purpose. Now, Amendment Rule 10. Please refer to page 15 of the marked up copy. We think that there's no need to retain Rule 51. That is the provision concerning allowing certain visits for providing bail. We want to, through the amendment, repeal Rule 51. Mr. Lai Tong Kwok. I want to know if anyone is being imprisoned now because of a default payment. Secretary. Well, I don't have the relevant statistics in hand, but there is a very, very small number of people who are imprisoned because of this. I have a follow-up question. You are repealing Rules 50 and 51. They are supposed to be some rights enjoyed by the prisoner. Now you're allowing Commissioner to exercise certain discretion. Unless there are some unforeseen situations, will you ensure that the Commissioner will, under normal circumstances, approve these visits? Administration. When the Commissioner approves certain visits, he'll have to consider certain factors. One of them would be the rights of the prisoner concerned. If you owe certain payment or you owe the payment of a bail, these may be reasons for the prisoner to receive a visit. Say a prisoner claims that he has to find way for people to help provide for the bail. If there are no national security risks or risks concerning prison security, normally the Commissioner would grant the approval. Let's move on to Rule 205. Same apply to Rule 26. Please turn to page 40 of the marked up copy. Based on bracket 203 bracket 2, the Commissioner may permit prisoners to see any of his relatives or friends for the bona fide purpose of providing bail. We think that there is no need to keep these provisions. That is, we are repealing Rule 205 so that we are not going to permit prisoners to see any friends or relatives just for the purpose of providing bail. Now, the amendment concerns Rule 167 and Rule 169. Please refer to page 30 of the marked up copy. to step up management of prisons and to safeguard national security, we are amending Rule 18 and we're introducing 169A. So that the superintendent, where necessary, may impose restrictions or conditions on any relevant function of the chaplains. This is not to restrict the religious freedom of prisoners, and this is not to prohibit prisoners from attending religious services or prohibit prisoners from receiving religious counseling. Therefore, we are protecting the prisoners' religious freedom even with the amendment. The amendment is to step up the management of correctional institution and to safeguard national security. Do members have any questions on 169A? Now we move on to policy area 2. Please refer to page 1 of the marked up copy. Before the amendment, according to the pre-existing rules, Part 5238 sets out the definition of barrister as well as solicitor. The amendment here is to move the relevant definition to Rule 1A. So the pre-existing definitions will be repealed under Rule 50 and 51. Now I will move on to the provisions about legal visits. Do members have any particular questions? If not, please move on. Now, Rule 11 to 13. Please refer to pages 16 to 22 of the marked up copy. This has to do with the visiting system. After amendment, the rules will empower magistrates to issue warrants under certain circumstances, to impose restrictions on prisoners. That is, the prisoner may not, during the specified period, see the legal representative, barrister, or solicitor, or anyone from the law firm that engage in the relevant work. There should be no correspondences between the prisoner and these people. We're introducing Section 52A, allowing prisoners to choose their own legal representatives. Under 52A, magistrates will only issue warrants under certain circumstances. The legal representative or relevant barristers or solicitors will endanger national security or cause bodily harm to any person. The prisoner has benefited from any criminal offense committed by him or her. According to the newly introduced 52A, this has to do with confidential information, so the CSD officer will make an ex parte application to the magistrates for the warrant. If the magistrate is of the view that inter partes application should be conducted to ensure the course of justice, then this should be the relevant arrangement. And the relevant application has to be done in closed court. If the magistrate orders that this has to be done in open court, then this will be done under this arrangement. However, this has to be done under the premise that national security will not be compromised. We're introducing 52B. If a CSD officer does not have reasonable grounds to believe that the circumstances mentioned exist, then the restrictions have to be ceased to be imposed, and the relevant party may apply to vary or revoke the warrant. On correspondences and letters, according to the new Rule 52C, if after the warrant is issued, the CSD officer will have the right to open or read a letter sent to the prisoner concerned to ensure that there are no correspondences between the prisoner and the relevant legal representative. The CSD has the right to stop any letter. The above mechanism is to ensure that the CSD can safeguard national security and, according to the magistrate's warrant, restrict any connection between the relevant legal representative and the prisoner. The prisoner will still have the right to choose to see other legal representatives, so their relevant rights will still be protected. And this is to ensure that the prisoner will have a fair trial under the relevant legal proceeding. And this is also to empower the magistrate to serve as the gatekeeper. This is in line with our safeguarding national security system. And this is in line with the policy intent of enhancing the legal basis for CSD officers to discharge their duties.
Any questions? Mrs. Regina Ape. So what safeguards is there in place to protect the rights of the PICs? Thank you. Mr. Leung? Thank you for the question. There is no specified time frame for the processing of the application. When ex parte application is launched, the judicial officers will try to process it as soon as possible. The reason why we ask the CSD to launch ex parte application is that there is such a need of urgency. Let me give you an example. When the police applies for a warrant from the magistrates, the magistrate may grant the warrant on the same day. Same goes with the ex parte application. The entire process can be handled within 1 day. So are you referring to ex parte application? Yes. Any follow-up questions? No. Any other questions? If not, please proceed. There are 2 corresponding amendments. Please refer to page 46 regarding the amendment to visit arrangements. The correspondence between the PIC and the legal representatives, barrister, or solicitor. Please pause here. Did you reach out 238A? When we talked about 1A, we have already covered that because 238A are to move the definition of barrister and solicitor to Rule 1A. We're just repealing 2388. Thank you. Under Rule 52 of the prison rules, we have made amendments to the visit system. So we are going to amend Rule 27 and 28 regarding the correspondence between the appellant and PICs and the barrister and solicitor. So we have made corresponding amendments. Any questions regarding 206 and 214? Mrs. Ip? Confidentiality is protected under the Bills of Human Rights and the Basic Law. Also, privacy is also protected under this Hong Kong Bill of Rights. Mrs. Ip, can you repeat your question? Because in the rules, it is said that the letters will have to be inspected by the CSD officers, and there are more restrictions imposed. Will the freedom and right to privacy of the PICs be affected? Thank you, Mrs. Ip, for the question. Regarding the correspondence between PIC and the legal representatives, it has more to do with the professional confidentiality and the right to confidential advice from legal representatives enshrined under the Basic Law. Because the appellants and the PICs may have to write to the legal advisors to give them instructions, they should not be inspected by CSD officers. If the CSD officers is of the view that the letters are not of legal advice in nature, they can open it and read it. As I mentioned, the CSD officers can impose restrictions of PIC's meeting with certain legal representatives or writing letters to them if authorization has been granted from the commissioner. Despite the prohibition, the PICs may still be able to send written instructions to legal representatives that have been barred by the commissioner. And if this happens, we have to put in place penalty. And that's why under Rule 206, we put in place, we amend Rule 52C. It says, subject to Rule 52C, a CSD officer may open the letter of a prisoner awaiting trial to see if they are sending letter to barrister or solicitor barred. So are we infringing the legal professional privilege? Well, only when the warrant has been obtained by the magistrate can the CSD officer open the letter. If we refer to Rule 52C, you will see a safeguard in place. Bracket 5. It says, if any officer of the Correctional Services Department reads any letter under Sub-Rule 2C and the letter does not contain communication between the prisoner and the relevant legal representative, the officer must not divulge the contents of the letter to any person. So if the CSD officers realize that the letter does not contain communication prohibited, then they have to respect the legal professional privilege. The speaker is not coming through. I think that there will be disciplinary action against the CSD officers if they divulge the contents of the letter. Thank you. If the CSD officers has opened the letter and they cannot decide how to act on it, can they talk to their supervisor or superior? Can they talk to them about the content? Or is it the case that once the letter's been opened, the relevant officer cannot divulge the content of it to any person? Can they talk to their superior about the content? Thank you. You may refer to Rule 52C bracket 3. It talks about who can read the letter. It's officer of Correctional Services Department not below the rank of principal officer. This officer of such a rank will have certain enough experience to see if the communication is sensitive or prohibited. We specified the rank of the officer to be someone not below the rank of principal officer. If the relevant officer want the, say for example, superintendent to read the letter, it is allowed under the rules. Reverend Peter Kun, thank you. Will the PIC whose letter been read be notified of it? Thank you for the question. Under Rule 52C bracket 3 bracket B, it says that the letter may only be opened or read in the presence of the prisoner, except where the prisoner indicates that they do not wish to be present. Thank you. Mr. Lai Tong Kwok. It says under bracket 5 that if the letter does not contain communication between the prisoner and the relevant legal representative, the officer must not divulge the contents of the letter to any person. However, if it does contain communication between the prisoner and the relevant legal advisor or representative, can the officer divulge the content to other people? Mr. Leung? By relevant legal representative, we mean the relevant legal representative prohibited under the magistrate's warrant. Any communication between the prisoner and other legal representative not set out in the warrant is allowed. However, if the letter does contain communication between the prisoner and the legal representative set out in the warrant, we have to act in accordance with 52C bracket 4. The CSD will either return the letter to the sender or destroy it. After the relevant officer of the CSD has read the letter, they would know what the content is about. If the letter does not contain the relevant communication, they should not divulge the content. But if the letter does contain the relevant communication, then the letter will not be sent to the prisoner. And in such a case, the officer have to note the content of the letter down and tell their superior, for example. I don't think that the CSD officer should divulge the content of the letter even if it contained the prohibited communication. They should either return the letter to the sender or destroy it. It seems that there is a loophole here. Mr. Leung, thank you for the question. We respect the legal professional privilege. After reading the letter, if the CSD find communication between the prisoner and relevant legal representative contained therein, if it contains genuine legal advice but not a content endangering national security, then the CSD officer should not disclose the content in accordance with the basic law. But there is a reason behind why warrant is sought from a magistrate. It could be that the correspondence between the prisoner and the relevant legal representative contain information that may undermine national security, and this will not be protected under legal professional privilege. And if this is the case, we have to refer the case to the relevant law enforcement agencies. I think that the answer is detailed enough. But I hope that the commissioner will try to improve your internal guidelines so that all affected persons and CSD officers will have rules and regulations to follow. Chairman, I have one more question. Why don't you press for the next round? Mr. Benson-Look. Thank you. I have a question regarding sub-rule 5. It says, the officer of the Correctional Services Department is to read the letter and decide whether the letter contained communication between the prisoner and a restricted legal representative. If the PIC knows that a certain legal representative is restricted, then they would not title the letter to the relevant legal representative. So how will the CSD officer decide whether the letter is sent to the restricted legal representative? I will take the question and then I will see if the Commissioner has anything to add. I think that our provision is clear enough. It says whether the letter contained communication between the prisoner and the relevant legal representative. So we don't just look at to whom the letter is addressed. We look at also the content of the letter. Let me give you an example. When a warrant is obtained from a magistrate to bar communication between the prisoner and the barrister, and when the prisoner writes to the solicitor, because usually the solicitor is the one to seek instruction from the barrister. Therefore, in the letter, the prisoner may ask the solicitor to request certain action from the barrister. And when this happens, we will be able to tell from the context that the prisoner is seeking communication with the relevant barrister that is restricted. Thank you. It says in the provision, the word contain. If we find out that the prisoner asked another solicitor to reach out to the barrister, we may apply for a warrant with the magistrate to also bar the other solicitor. We may also restrict the entire law firm from being in touch with a particular prisoner. Mr. Lai Tong-kwok, thank you. The question regarding Sub-Rule 4. Once an officer of the CSD finds out that there is such a letter, they may either return the letter to the sender or destroy the letter. So under what circumstances would you return it, and under what circumstances would you destroy it? If you have destroyed it, then no one can argue against the decision. What happens if the persons affected lodge a complaint? If they have questions regarding your decision, they have evidence to act on. They can lodge a complaint. If you've destroyed it, then they have no way to do so. So under what circumstances would you invoke your power under Sub-Rule 4A and 4B? Secretary. The purpose of this provision is about, well, the content of the letter. If the prisoner is trying to send tips to the sender, then we should not return the letter. If the content of the letter has to do with criminal offense, then the letter will become a criminal evidence. And we will act accordingly. Mr. Lai Tong-kwok. Under Sub-Rule 4, there are only two choices for the CSD officers. They either return it or destroy the letter. However, if criminal elements is involved, the CSD officer has to retain it. They should not exercise Sub-Rule 4A. They have to keep the letter. Is that the case, Chairman? Secretary, thank you. Yes? If the letter becomes a piece of evidence, then we will hand it over to the law enforcement agencies. And we may seize the letter as evidence, and there are procedures to follow when that happens. Any follow-up questions? So regarding a communication between prisoner and relative legal representative, any other questions? If not, we'll not go back. Thank you.
Please proceed. Thank you. I will talk about For the amended rules, Rule 24 to 25, please refer to pages 36 to 39 of the marked up copy. This is in relation to the mechanism where we may bar certain visits made by medical practitioners. Such visits are not for treatment received by the prisoners. It is about how they are trying to conduct a defense or lodge an appeal. So we have for this mechanism for prisoners awaiting trial, they would have a similar mechanism for what we have when we talked about the mechanism for barring certain prisoners from connecting with legal representatives. But the appellants and PATs can always receive visits from other medical practitioners. And as said earlier, like we have for legal representatives, the magistrate must consider the relevant circumstances before issuing a warrant. And in Rule 204 and the new Rule 204A, we have specifically for prisoner awaiting trial what they can do in relation to the visiting arrangements and conditions may be imposed. The mechanism works just like how what we have for legal representatives, and the magistrate may vary or revoke the warrant at any time. Thank you. Any questions? None? Please proceed. For appellants, we have a similar mechanism that is in the amended rules, Rules 28 to 29. Please refer to pages 42 to 45 of the marked up copy. You said pages 36 to 39, but that is not the case. It should be pages 42 to 45. Excuse me, that is correct. Please refer to pages 42 to 45 of the marked up copy. The drafting of the relevant provisions are just like what we have for the amended rules for 24 to 25. This will help us better enforce the relevant provisions, and these also have to do with national security considerations. All right, any questions? If not, let's move on to part 3. Thank you. We're now going to look at Rule 3 of the amended rules, page 2 of the marked up copy. This has to do with the provision of uniforms to prisoners. We want the considerations to be clearer, which is why we're amending the prison rules to say specifically the aims for providing uniforms. That is to ensure the safety, comfort, health, and hygiene of prisoners, safeguarding prisoners' privacy, ensuring that prisoners are decently dressed, ensuring that prisoners are suitably dressed during the course of work or other activities, and maintaining the security, good order, and discipline of the prison. Any questions? Yes, Mr. Stephen Ho. The speaker's microphone is not on. Thank you, Chair. I have a simple question. The original provision says that the clothing should be adequate for warmth. We do not say that in the amended Rule 26. Is that covered under ensuring the safety, comfort, health, and hygiene of prisoners? Secretary, yes, we are going to cover that with Sub-Rule 2A. I want to ask, will there be more specifics, say how many buttons have to be buttoned up? Secretary, I think we can go with common sense. I think it has always been the case that we should go with objective standards, like what people think in general. I guess we shall see. Dr. Chen Han Pan, I want to ask, for PATs, they will wear uniforms, they will no longer get private diet, but I want to ask, where they take a rest or where they sleep, are they separated from prisoners in general or prisoners in custody? They are detained separately. Thank you. Any other questions? Reverend Peter Kuhn. I agree that there should not be private clothing, but I want to ask, would you consider having different uniform colors to separate the different groups? It's just from a psychological perspective. It may work better, Secretary. Well, actually, it is already the case that PICs and PATs have different uniform colors. All right? Any other questions on this? If not, I would like to ask if members want to take a break. If not, we can go on. Should we go on? Let's go on. Okay, next we will be talking about the repealed rules 192 to 197. Thank you. Please refer to pages 31 to 32 of the marked up copy. Seeing there are relevant risks with private diet and private clothing, we plan to, as said earlier, we are repealing the rules for private clothing and private diet. And we have repealed the rules specifically to have effective enforcement of the correctional services, and we would also like to address the national security risks. Mr. Tommy Zhang, we have been talking about developing silver economy, and we have talked about soft meals. If one has to eat soft meals and prisons can't provide such, can the Correctional Services Department provide soft meals to prisoners if there are medical needs for such prisoners to consume soft meals? Secretary, if there are medical needs, we can already provide soft meals. We actually have a supplier of soft meals. Oh, you can do that? I'll let the commissioner supplement my answer. Right now, we have meals prepared within the correctional institutions, and prisoners who work in the food preparation duties, they are taught how to prepare soft meals, and soft meals in general are consumed by elderly persons or those with teeth difficulties. We also have porridges or other soft food that may be made available for consumption of prisoners with such issues. All right, so in general, correctional institutions can already provide the different soft meals to those who need such. Correct. All right, any other questions on the repealed rules 192 to 197? If not, let's move on. We will now move on to another policy area that is for the better enforcement of the regime to safeguard national security and the enforcement mechanism. So we need to make sure officers would consider the purposes to safeguard national security. We have in different provisions made some adjustments. Specifically, if the Correctional Services Department has reason to believe an act or a particular matter may bring about specified effects, the Correctional Services Department may impose some restrictions. Now, let's first talk about the rules in relation to sending and receiving letters by prisoners. Pages 3 to 5 of the marked up copy. So, if a prisoner's letter is believed to will bring about one or more of the effects mentioned in subrule 6A, that will endanger national security, that will not help with preventing or detecting any criminal offense, that is the key purposes, then the officers can prevent the sending or receiving of relevant letters. Any questions on this? None, please proceed. Let's now look at pages 6 to 11 of the marked up copy. Amended rules 5 to 8. So if we have in the reading that will threaten the key purposes. That will assist in the relevant purposes because the letter will endanger national security, then the Correctional Services Department officers may read the relevant letters, that is the prisoner's outgoing and incoming letters. The letter may also be retained or stopped. If a letter is read and the letter contains one or more matters mentioned in subrule 5. Alright, Mr. Dennis Leung, I want to ask, we have talked about, say, a distinction between prisons and a maximum security prison. So when you say specifically in Chinese, with the use of 者 with maximum security prison, what does that mean? Mr. Vincent, why? Well, that is just a reference. It is often how we draft provisions. In 47A, we have talked about maximum security prison. And maximum security prison we have a definition in subrule 1. Specifically in subrule 1B, it says specified as a maximum security prison in a notice displayed in a conspicuous position in all prisons. And when we say that, it just refers to maximum security prison. And this is a common way of drafting provisions. Thank you. Any follow-up questions? None? Not really. I just find it to be a bit strange. Maybe you're not a legal professional, which is why you are not well versed in such practices. Yes, Mr. Dennis Leung, the speaker's microphone is not on. I have another question about 47A for subrule 5C. With any information on escape plots, does that cover one's escape plans from a prison? I also want to ask in paragraphs GHI, it seems that there are different ways of referring to correctional services department staff. Some you said they are officers, some you said they are staff members. Why is there such distinction? I also want to ask in Rule 7, sometimes you would say withhold the letter, sometimes you would say retain the letter, sometimes you would say stopping the letter. Are there any differences in the use of such terms? What are the specific differences? Mr. Ivan Leung, I will answer the first two questions, and I'll have the law drafting division officer answer the third question. Escape plots would cover escape plans from a prison, and for the distinction between staff members of the CSD or CSD officers, we have talked about this in Division 5. We have different categories of staff members. We have commissioner, deputy commissioner, we have superintendents, we also have civilian officers. With staff members of the CSC, it would be the broadest one. It refers to all staff members of the CSC. When we talk about preventing the sending of letters, we want the broadest definition because we may have more officers or staff members dealing with such letters. As for specific enforcement duties, then we would restrict that to, say, chief officers, principal officers, or even superintendents. So there is such difference. I'll let the law drafting division officer answer the third question. Thank you. The member mentioned how there are 3 different terms used: withhold, retain, stop. I would say the 3 would have generally the same meaning, but they have different foci. We have for stopping the letter. It is about stopping, as the word suggests, or intercepting a letter. When we talk about in 47A sub-rule 7, A, Roman numeral 2, capital letter A, withhold. It is about withholding the letter. And in capital B, after informing the prisoner that he is doing so, file it in the prisoner's penal record. So there is filing involved, which is why withhold is used. We have in our new provisions. So in sub-rule 7, B, Roman numeral 2, capital B, we say retain. It is because after stopping the letter, one can either withhold the letter, or we have in here for paragraph B, Roman numeral 2, return the letter to the sender, retain the letter, or destroy the letter. So we have retain the letter here. So they 3 terms have generally the same meaning, but they have certain differences and nuances. Thank you. Dr. Chen Han-pan. I think it's very clear what we're going to do with letters sent by prisoners, but if letters are sent to the prisoners from the outside, we may have the letter destroyed. You said earlier, if the address is not clear and the letter cannot be returned to the sender, then the letter may then be retained or destroyed. What are your criteria for doing the respective actions? Secretary, we would refer to the circumstances and actual needs. Say, as you said, if we do not have a return address, and if there is no need to retain the letter or keep it as evidence, then we will destroy the letter. If we think there is a need, or the letter may be returned to the sender without compromising national security, we will return the letter to the sender. As for if we have to retain the letter for other proceedings or keep the letter as evidence, then we will retain the letter. So it would depend on actual circumstances. Secretary, who will decide whether the letter will be retained, destroyed? Would it be a superintendent? I think it says here that it should be a superintendent. All right, thank you, Mr. Tang Fei.
多位主席，
Thank you. I want to ask about 7B2. Here it says that the letter may be kept. What kind of legal consequences will the prisoners face? Now, apart from 5, that is letter that over 4 pages of A4 size paper. If it is longer than 4 pages of A4 size paper, the letter may be kept. So what does it mean here that the letter may be withheld or filed in the prisoner's penal record? Secretary. When a letter is filed, well, depending on the prisoner's performance, we will take the letter filed on record as part of the consideration when we consider the performance of the prisoner in future. Do members have any questions? If not, let's carry on. Please refer to Rule 5 to 6, that's page 10 and page 11. 47B, letter to or from prisoners, solicitor or counsel, unless the letter is opened in front of the CSD officers or that the prisoner indicates that the CSD officer should not be present, otherwise the CSD officer should not open the letter. 47C, letters to or from specified person. Except in the presence of the prisoner or unless the prisoner indicates that he does not wish to be present, CSD officers must neither open or search the letter. 47D, supplementary provisions for Rules 47A, 47B, and 47C. If a prisoner sends a letter to a person, but the letter is returned by the post office because it's undeliverable for any reason, the letter is to be treated as a letter from the original recipient to the prisoner. Do members have any questions? No? Please carry on. Please refer to Rule 14, that's page 23 of the marked up copy. This is about handling publications from outside the prison. If the superintendent has reasonable grounds to believe that any publication approved under Sub-Rule 1 will bring about one or more of the effects, that is brackets A to E, the superintendent may withhold and dispose of the publication. Brackets A to E include being contrary to the interests of national security, tending to cause the commission of any criminal offense, being detrimental to the rehabilitation of any prisoner, posing a threat to any individual's personal safety, and posing a threat to the security of the prison. Mr. Dennis Leung, is there a definition for publications? Does that cover all kinds of books and newspapers? Is there a clear definition of the word publication? Mr. Leung? I thank members for the questions. There is not a specific definition under this rule for the word publication, but under Cap A of our law, there is a definition for the publication that includes all kinds of articles published. So newspapers, magazines will all be covered under the meaning of publication. Any follow-up questions? Yes. 56 bracket 2 bracket A. Being contrary to the interests of national security. Our focus for the amendment is about safeguarding national security. Here, being contrary to the interests of national security has a broader meaning. It's different from safeguarding national security, is that right? Administration. Being contrary to the interests of national security. This is cited in many other legislations, such as the Safeguarding National Security Ordinance. This phrase appears a number of times in the Safeguarding National Security Ordinance. In other legislations, we also cite this phrase. Any other questions? If not, let's carry on. 68B. Please refer to Rule 16, pages 26 to 27 of the marked up copy. This is about removal from association. According to the amendment, CSD officers may, for one or more of the purposes mentioned in Sub-Rule 10, order the removal of a prisoner from association with other prisoners. The purpose is to safeguard national security, maintain the security, order, and discipline of the prison, and so on. Any questions concerning 68B? No? Rule 202. Please refer to Rule 21 and Rule 22, that's page 33 of the marked up copy. Supply of means of occupation. According to the amendment, CSD officers must supply to any prisoner awaiting trial, as long as the superintendent has reasonable grounds to believe that the supply will not bring about one or more of the following effects. That's A, being contrary to the interests of national security, B, tending to cause the commission of any criminal offense, C, posing a threat to any individual's personal safety, and D, posing a threat to the security of the prison. The above amendment is to safeguard national security and to maintain the security of the prison. Mr. Dennis Leung. 234A doesn't provide a definition for means of occupation. Should we follow the definition under Cap 1 of our law? Mr. Leung or Secretary? There is no definition for means of occupation under Cap 1 Interpretation and General Clauses Ordinance. According to the CSD, guitar could be one of the means of occupation. Any follow-up questions? Any further questions on Policy Area 4? If not, let's move on to Part 5, Rule 237 to 238 AAC. Now we move on to Policy Area 5, to step up the law enforcement effectiveness of the CSD. Please refer to Rules 31 to 34, that's pages 47 to 50 of the marked up copy. Here it says that no officer of the CSD may use unnecessary force in performing a function as such an office. We drew reference to other legislations, and we are introducing Rule 238AA. We are providing for an offense of resisting or obstructing officer in performing certain functions. Those who breach this part of the law will be liable to a fine at level 1 and to imprisonment for 6 months. We are also adding 238AAB. Power of officer to arrest. The CSD may arrest people who take part in riotous conduct and who attempt to escape from the prison. The CSD may forcibly may use reasonable force in the arrest. We are also adding 238AAC. Under specified circumstances where threats is posed, the CSD may use arms against persons who attempt to escape from the prison, who take part in riotous conduct or combined outbreak. Also, to ensure that CSD officers is not civilly liable for an act done or omitted to be done, we drew reference from Section 53 of the Public Ordinance as well as Section 21 of the Customs and Excise Service Ordinance. We are introducing this new provision so that CSD officers can be civilly immune for any acts done or omitted to be done by the officer in good faith in performing or a function as such an officer. Mr. Dennis Leung. There is substantial amendment under Rule 237. For example, the phrase "no more force than is necessary shall be used" has been removed. I understand that under other legislation such as the Police Force Ordinance, no more force than is necessary shall be used. Also, when an officer is to use arms, he'll have to abide by the principle of use of force continuum. However, this is not included in the rule. Is this covered in the guidelines or code of conduct for CSD officers so that CSD officers can, in accordance with the guidelines, use force and arms against prisoners? This is to protect CSD officers from being civilly liable as cited in 238 AAC. So my question is, how can we protect CSD officers from using force and arms against prisoners? My second question concerns 2381E. It says here, a person uses violence to an officer of the CSD performing a function. Can we split this into 2 sentences? This is my suggestion. Also, sometimes an officer may use arms in different scenarios. Say for a police officer, if he notices that someone intends to use violence, the police officer may resort to arms or force. Now 238 AAC bracket 2. According to this part, the CSD officer concerned will be civilly liable. So how immune will the CSD officers be from civil liability? Secretary. Let me address part of the questions about the use of force. Under CSD, there is a stringent code of conduct stating under what circumstances can force or arms be used. The guidelines have a binding effect. If officers do not follow the guidelines, they will be subject to disciplinary actions. 238 AAC says that Sub-Rule 1 does not affect any liability of the government for the act or omission of any officer of the CSD. That means the government may take up the civil liability or the liability to make compensation. Mr. Y, if I understand members correctly, members' question is whether 2381E could be split into two sentences. When we did the drafting, we want to state the actions that is applicable. A person uses violence to an officer of the CSD performing a function as such an officer. That's the first part of the sentence. The second part refers to a person uses violences to a prisoner. So both parts refer to violence being used against others. And we think that combining the two into one sentence is appropriate. For those who attempt to use violence, would that situation be covered under this part? Mr. Leung, it depends on the actual circumstances. This provision is specifically about the use of violence. Attempting to use violence, for example, if a knife is taken out by a person, that's the person using violence, not attempting to use violence. But if a person is just making verbal threats without actually using violence, then there's no need for the officer concerned to resort to arms. So it really depends on whether the targeted person is using violence. Mr. Tang Fei? Please switch on the microphone for Mr. Tang Fei. The echo is huge. Please adjust the echo. On the use of arms, the new rules state very clearly that the CSD officers will be immune from the relevant liability. So I have no questions about the use of arms, but I have questions about bullets. Will the code of conduct state what kind of bullets will be used, such as cartridges? Will there be restrictions on what kind of bullets should be used? Also, Item 7 of the pre-existing rule states that the use of arms under this rule shall be as far as possible to disable and not to kill. Under the new amended rules, are there any corresponding provisions that cover this meaning? That is to prevent CSD officers from using arms to kill. Secretary. The CSD mainly uses, for example, pepper bullets or plastic bullets or rubber bullets that are non-fatal. This is to stop prisoners from using violence. And this kind of bullets or arms are part of the broader definition of arms. As to what kind of arms will CSD officers use, these will be set out clearly in the code of conduct and the guidelines. For example, what kind of bullets should be used and what kind of arms should be used. And to move with times, from time to time, we introduce new guns or new bullets. And we update the guidelines and code of conduct correspondingly.
Mr. Lin, I will take the second question regarding sub-rule 7 under existing rule 238. This does not exist under our amendment. We find the drafting of the provision is rather weird. It says the use of arms is not to kill. I think that this is an agreed principle. That's a given. Under Rule 237, we see that no officer may use unnecessary force. Under this principle, no CSD officer should use force to kill. They only do so to cater to the circumstances set out in Rule 238. If you refer to Sub-Rule 2 under 238, it says that the officer is to use arms to stop an act mentioned in Sub-Rule 1. So definitely the officer will not use arm to kill, and that's why we remove the relevant provisions. We think that the drafting of the sub-rule is rather dated, and that's why we repeal it. Thank you. Mr. Benson, look. Thank you. Chairman. There are a few sub-rules on scenarios that happen within the prison. If a prisoner escapes or attempts to escape, this act may not only happen within the prison. Say, for example, it may happen when the CSD officer is escorting the prisoner to court or to hospital. So is there any restrictions as to where the CSD officer can use arms? Second, under the amended rules, will more CSD officers be equipped with guns? Will they receive training to adapt to the new rules? Thank you. Secretary. We refer to 2381A. It says this rule applies if a prisoner escapes or attempts to escape or prison assists a prisoner in escaping. If this happens, the CSD officer can use arms or use force. After amending the rules, the CSD officer will not be given new equipment or new arms. We are only reflecting the existing duties of the officers. If necessary, we will review the equipments and arms and strategies of the CSD. Thank you. Mr. Sip. I have a question regarding Rule 238. Mr. Sip, please speak into the microphone. (238)(1)(a) to (e) sets out the scope where the rule apply. What happens if scenario outside 1A to E happen? Will CSD officers be allowed to use arms? Under scenarios D and E, CSD officers can use arms. Is that too restrictive? Because some prisoner may not be trying to escape, trying to commit riotous conduct or dig a tunnel. Will CSD officers be able to use arms, say for example if the prisoner tried to set a fire in the prison? Are scenarios D and E too restrictive? Thank you. Thank you for the question. If the scenario does not fall within 1A to E, then we have to act in accordance with the common law system. we will see if we should allow the relevant CSD officer to use arms. Under the common law systems, very rarely would legal officers be able to use arms or lethal weapons. They can only use them to protect themselves or protect the lives and property of other people. Only under these circumstances will the legal or law enforcement officers be able to use genuine firearms. If we look at D, subrule D, it says a prisoner uses or a person and a prisoner jointly use violence to another person. By another person, it could be someone not being a prisoner or a CSD officer. It could be someone outside the prison, because the prisoner may use violence after they have escaped. A prisoner may cause injury to regular members of the public after they have escaped. And under this circumstance, the CSD officer may still use arms. I recall some 22 years ago, there was a riot in Heilongjiao. There was a prisoner who tried to brew wine, and they set fire to the wine. Well, that falls within 1B. A person participates in or facilitates collective disturbance of prisoners. I think that covered the example Mrs. Ip just quoted. Thank you. Any other questions? Any other questions? Let's move on to 67. Please refer to page 24 of the marked up copy. We amend Rule 67, bracket 1, bracket B, to ensure the safe custody of prisoners during removal or while outside any prison and illegal custody. They may use mechanical restraints approved by the Chief Executive. This is to further empower the CSD officers in their enforcement system. Thank you. Are we talking about Rule 67? Yes. Under 67, bracket 1, A, B, C, well, when these happen, mechanical restraints will be applied. However, we have to notify the medical officer and visiting justices when mechanical restraint is to be used, and we have to obtain a consent and approval from the medical officer before a mechanical constraint is to applied. And if not, we have to act in accordance with the recommendations of the medical officer. So how will the medical officer decide whether mechanical restraint is to be used? Secretary, I can give you an example. For a pregnant prisoner or someone who has seizure, we have to apply other forms of legal and reasonable means to restrain them. So if we have a pregnant prisoner, then we may not, we should not apply mechanical restraints. So it seems that the medical officer has a lot of power. Well, I think that the medical officer will give medical advice from their professional point of view to see if mechanical restraint should not be applied due to medical reasons. Well, but that's not set out in the provision. It sets in the rule that a medical officer can decide against the use of mechanical constraints or restraints. Secretary, medical officer, according to common understanding, only give medical advice. So I believe that's the legislative intent. I was just seeking clarification. Any other questions? If not, we've completed the policy area 5. Let's move on to 6, area 6. Thank you. Last, policy area 6, for making the prison rule more up to date. Please refer to page 1 of the marked up copy. Please speak into the microphone. As the District Council has been referred to being district advisory and service bodies, we have amended the definition of specified person by taking away BC members from the definition of specified person, so that persons fall within the scope of specified persons only include those whose duties necessitate the handling of PIC's complaints against CSD or its officers. The CSD will handle letters between PICs and DC members in accordance with the general provisions relating to letters, that is Rules 47 and 47A in the prison rule. This is to keep the prison rules more up to date. Any other questions? Lastly, please refer to amended Rule 17, that is page 28 to 29. Rule 144, bracket J, bracket C says that the medical officer should attend on every occasion when corporal punishment is inflicted. As we no longer have corporate punishment or execution, we are proposing to repeal the relevant provisions. Mr. Dennis Lang, thank you. I have no objection to repealing bracket J, bracket K. So medical officers have to visit every prison under Rule 144. I wonder why medical officers are asked to visit every prison. Secretary, I will ask the Commissioner to answer this question. The role of the medical officer in prison is to make sure that there is a good and healthy environment. During a pandemic, the medical officers will have to advise us on how we can make sure that the health conditions of the prisoners is good enough. Any other questions? If not, we have completed the 6 policy areas. Altogether 30-odd amendments to the rules. Legal advisor, any questions regarding the English rendition of the marked up copy? Well, apart from the questions we sent to the administration, we have not found any legal or drafting issues in relation to the amendments. And the English and Chinese versions of the amendment rule is consistent. If members would like to propose amendments to the amendment rules, please do so before 5 p.m. on the 8th of August, Friday. Upon receipt of the proposed amendments, the Secretariat will ask the administration to give a written reply. Any other business? There being no other business, if there is any proposed amendments by the members and any response from the administration, we will send them to the members. The meeting adjourned. Thank you.